morning's docket. Case number 111047 in the matter of Mark R. Singer.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll. Mr. Chief Justice, I ask for 3 minutes for rebuttal.
3 minutes is granted.
As the court is aware that this case comes to you from an original proceeding in discipline in which a hearing panel found that the respondent, Mr. Singer, violated Kansas Rule of Professional Conduct 4.1b, which is truthfulness in statements to others, and Kansas Rule of Professional Conduct 8.4c for engaging in dishonest, deceitful, or fraudulent conduct. This finding was based upon a jury verdict that was affirmed upon appeal, in which there was a $1.7 million adverse judgment entered against Mr. Singer. The hearing panel concluded, based upon the evidence presented and the jury findings, that Mr. Singer's actions were intentional, and that finding is absolutely supported by the record. The respondent has requested probation. He did submit a detailed plan. He did have it in place prior to the hearing. He did provide affidavits to the court and to the Office of the Disciplinary Administrator showing that he is alleging that he is in compliance with this plan. I would note that the affidavit provided by Ms. Norton, who says that she served as his counsel in attempting to negotiate a settlement outside of the verdict, there aren't any dates that indicate when those settlement offers were made, and so I am not aware if that was a current situation or if that was something that occurred back at the time of the trial. Mr. Singer himself testified that there had been a settlement during the scope of the underlying case. It is the Disciplinary Administrator's Office position that the panel was correct that this type of misconduct cannot be corrected by probation, and so we start with the standards relating to what discipline should be meted out. And if you start with disbarment and apply the mitigating factors that the panel correctly found, a suspension is the appropriate resolution for this. So I would ask that this court affirm the panel's findings and the order of the 2-year suspension.
And there's also a discussion about probation or supervised probation would not work at all, so he would serve his 2-year suspension, then be allowed to come back in.
Correct. I believe that there probably should be a reinstatement hearing to show what efforts were being made regarding the judgment.
All right. Any other questions? Thank you, counsel.
May it please the court, Daniel F. Church on behalf of Mark Singer. And I am requesting, Your Honor, if it's permissible, Mr. Singer would like to address the court for 2 minutes as well. Thank you very much. Appreciate it. I've had the honor and pleasure of being here before you on behalf of Mark Singer. He's a 40-year attorney who's never had a disciplinary matter besides this one. He's 75. He was admitted to practice in Kansas and Missouri, and he has an active practice of real estate and commercial transactions. He has been with firm. He's been a solo practitioner since 2001, and I think that his practice really involves some complex real estate transactions. He developed a little bit of a niche in the hotel purchasing business and represented a buyer or buyers in hotel purchasing. The buyer and the seller in this transaction were familiar with each other, had been involved in prior transactions. Mr. Singer's role in this was principally preparing documents. He was not involved in the negotiations at all as it relates to how the closing was to occur, in terms of what the financial implications were. That was not his involvement at all. So that Mr. Singer did get involved in this transaction, unfortunately, and a bad outcome clearly occurred. There's no question. Lawyers titled, settled the case. In fact, there was 4 mediations before the one that Mr. Singer didn't go to, that was a Friday before the trial where the settlement occurred. Tragically, he wasn't there. There was an opportunity apparently for $200,000 settlement for him. He's made that offer immediately before trial. He made it during trial, and he's made it after the trial. And I think the evidence from the Honorable Cynthia Norton, who's a bankruptcy judge in the Western District, was Cynthia Grimes at the time representing Mark, made that offer clearly with $100,000 of Mark's money and $100,000 from the insurance carrier. Mark has also set aside a fund, a restitution fund, if you will, since this judgment. And he has taken that money and set it aside as a separate account so that he can have an opportunity to satisfy this judgment. Lawyers' Title has refused and absolutely not responded to any of the offers made. They will not talk with them, and so there's not been an ability to do that. I want to talk briefly about a couple of things I think that are critical to the analysis of this case. I'll probably end with a talk about probation. I will tell the court that the probation and suspension plan that we've put together absolutely 100% addresses any concern this court may have relative to Mr. Singer's conduct and his ability to practice law. It protects the citizens of the state of Kansas, and it protects his clients, and I'll explain how in a minute. And that's why we put together this plan, because we felt like it was the most appropriate course of conduct going forward. Mark Singer has practiced 12 years since this incident. He's had no involvement with any disciplinary complaints or ethic issues. He has been practicing for 1 year under this probation plan that we implemented prior to the hearing. And so I think that's clear evidence of where he's been. He intends and will and wants to make restitution. So there is really no case like this in Kansas. I know the hearing panel said, well, we're going to apply the criteria from the Roush case. Well, Roush is a case where an attorney stole money from the client through his own IOLTA account. The Baker case is another case where there's a discussion about probation. Well, in Baker, the lawyer stole $2.6 million 36 times from their client. What's substantially different is that this is not a pattern in practice. This man has never been involved in any issue before. Those cases involve pattern and practice of fraudulent conduct, and that's why the court administered the appropriate discipline there.
Counsel?
Yes.
I recognize the distinction from those two cases, but I just am curious that the way I read the paperwork here, your client did not expect the closing to happen because he expected at least one of two parties to uncover this problem of not enough cash changing hands. And it sounded like he expected it, either the title company to figure it out or the lender themselves.
I think that's an accurate statement, Your Honor.
Okay.
I think that
So there was opportunity to reconsider what he was doing. I mean, probably quite a bit of opportunity.
And he did.
Okay.
And he did exactly what a reasonable attorney would do under the same or similar circumstances. He actually went back to his client and said, I am concerned about how you're structuring this transaction. This could happen. Give me an explanation. And he provided them with a reasonable explanation. This was a client that he had represented previously, and they explained why and how the transaction was being orchestrated in this fashion, which Mr. Singer felt like was a reasonable explanation. He also told him that his client that it may not close, that this issue could cause it not to close. But I think he was in a very difficult situation because he had a client requesting him to advance their position, and that's what he was doing. He was representing his client, so it was a very difficult situation for him in that regard as well. And I don't think that he had a dishonest motive. Mark Singer didn't make any money from this deal. He did get his fees, but he didn't take clients' fees. He didn't have a selfish motive here. And in fact,
it's not a theft, but he got paid to do something for the client that a lawyer should tell the client he or she won't do.
I would agree.
I mean, so he did benefit from not standing up to the client when the client needed to be stood up to.
Oh, I think Mr. Singer would tell you today, absolutely.
Okay.
100%, Judge. He would say, I made a horrible mistake. It was an error in judgment, and I shouldn't have done that. And that was a big mistake. And the worst mistake of his life. And you'll hear him. I think you'll probably hear him say that.
What was the error of judgment? I mean, there's no judgment to exercise here when you're talking about fraudulent misrepresentation. That's not a discretionary matter.
Well, I think that he was involved in this process, telling his clients that I don't know that Mr. Singer appreciated that it was a fraudulent misrepresentation. In fact, the jury instruction in the case provided, and we don't know the outcome, but the jury instruction says, proved by clear and convincing evidence that Singer knowingly made a false statement or material omission, or that Mr. Singer made a statement or omission with reckless disregard of the truth. And I think that's critical because that's what the jury was faced with and how they made a decision in this case. So whether Mark Singer was reckless in this regard or he knowingly did it, we don't know what the jury's decision was, but I believe that the evidence clearly shows that Mr. Singer was, if he was reckless, clearly in exercising bad judgment. But I don't know that he necessarily had a dishonest motive to commit fraud. And I think that's a critical component of the mental state that you require to find if you want to suspend him from practice. So I think that clearly some of the issues that for the court to consider, the 7 factors of restitution.
Before we proceed there,
Yes, sir.
I'd like to go back to the comment you made. The hearing panel concluded his conduct, quote, was dishonest, fraudulent, and deceitful, unquote, in violation of 8.4C. And according to my notes, he admits he violated 8.4C.
I think that's...
So have I misinterpreted something?
You have not, Judge. I think we've admitted that he had violated the... we admitted that he violated the standards of the ethical codes provisions, as you stated. I think what we're talking about a little bit differently is his mental state and how that might relate to a mitigating factor or not relative to the court's imposing discipline. So it may be a fine-tuned distinction, Judge, but that's the distinction I think that we're talking about. The 7 factors for the court to consider on the discipline are restitution, absence, previous violations, clearly a good reputation. He cooperated. He did. Support by members of the bar. He is. Was restitution made? You've heard about the restitution status. And then are there any personal misfortunes? And so we don't believe there are any of those, obviously. So the question kind of comes down to, under the ABA standard, which the panel approached was 511, and that involves an intentional, conscious, knowingly fraudulent act, much more similar to a pattern in practice. 513 of the ABA guidelines, however, talks about a much more appropriate standard, which is consistent with the facts in this case, which clearly are that Mark Singer did not commit a pattern in practice. He didn't steal clients' money. He didn't commit a crime. But he did, and he was found guilty on an indemnity action by lawyer's title, no question. So my point is that one size doesn't fit all. And let me tell you a little bit about the probation plan so you understand. Kelly Dunn Walters is the attorney. 25 years as a title insurance attorney involved in real estate transactions. She's been involved in mezzanine financing transactions. This attorney absolutely can uncover, and that's what she does, any inappropriate documentation or efforts by an attorney to mislead someone. She has been monitoring him for a year, put together a plan where Mark meets with her monthly, reviews all his files, all his documents, submits quarterly plans, which we have to the court. And most importantly for you all to know, I think, is that during the course of her involvement as monitoring counsel for Mr. Singer, he has been involved in a hotel sales transaction. One not like this, but similar to this. And she had an opportunity to review all of those documents, the closing documents, every document associated with that transaction, to make sure that it was appropriate and not involving a similar conduct or any type of conduct that gave rise to the misfortune why we're here today. And candidly, she found that his records were perfect. In fact, she testified at the hearing that when Mr. Singer appeared before her on her closings, she was pleased because she knew that he was professional, he was thorough, and he always did a good job. And that this instance clearly was an anomaly in his practice. And so the question I think that we're asking you is, one size doesn't fit all. You know, after practicing for 30 years before you all and many other courts, and handling disciplinary complaints and investing disciplinary complaints, they don't all fit. They really don't. You have to look at each case and look at each fact. If Mark Singer, at 63 years old, is suspended from practice, he's done. He's finished. He doesn't have any clients. His clients can't come back. He doesn't have a firm. He doesn't have any other lawyers. The clients will be gone, and he would be hampered to make restitution in this case as well. So I think it doesn't serve a meaningful purpose. The citizens of Kansas are being protected by this plan. If you all feel that the plan should be extended beyond what period of time it has been, we're perfectly fine with that. But Mark Singer deserves a chance. I think he's proved to you all that he is a competent lawyer. He made a horrible mistake, and he is sorry for it. And he would like an opportunity to show you that suspending him wouldn't be an appropriate discipline. It's excessive for this instance, and allowing him an opportunity to show you that he is a good member of the bar and a good standing member of the bar would be important.
Before we proceed to that stage, I want to go back to the general issue I raised earlier, and that was the acceptance by you and your client of the ruling by the panel that he had violated Rule 8.4C, and that says, quote, dishonest, fraudulent, and deceitful, unquote. And I understood you to say you were talking about mitigation a few minutes ago in terms of what level of discipline might be imposed, and you were, as a result, emphasizing his lack of intent. Is that a fair characterization?
I think that is a fair characterization if you would characterize it in that fashion. I think his conduct was, if it was deceitful, I suppose you could characterize it as that, as if it's an intent, a reckless disregard for the truth is deceitful. I suppose that could be the case. And we're not here challenging that the panel made those, the findings for those particular violations.
I understand. My question is, in dealing with the part of 8.4C that talks about his being found dishonest, it sounds like you're telling me he did not intend to be dishonest. And I'm having trouble figuring that out.
I'd probably let Mark answer it. It might be better than it myself, but he did not. I don't think that he intended in the transaction to deceive anyone. He was following his client's request.
And counting on someone else to figure it out.
Well, I don't know that he was counting on someone else because the seller had two lawyers, the lender had two lawyers, and he had...
That's what I was trying to ask about earlier, counsel.
Yeah.
He was counting on either the title company or the lender to figure it out on their own.
And I think what he was counting on was whether it would be an issue. Even if they did figure it out, was it going to be an issue or not? Because he didn't know, because he wasn't involved in the negotiations. And so even if they had found out, it might have been a non-issue or not. I think that's where the quandary that Mr. Singer found himself in, is that since he wasn't involved in the negotiations between the buyer and seller, he didn't have the ability to size up that issue and say, this is fraud and I'm advancing this as a fraud, as opposed to I'm advancing what my clients are directing me to. I think there could be some problems with it. Told his client, they gave him an explanation. He said, okay, I guess I get that. I don't know if it's going to pass muster or not, but we'll present it and see what happens. I think those are the facts. If that's intentionally committing fraud, then it is. I don't know that it is. It's a difficult situation for him as it relates to where he's at representing his client.
Well, you can commit fraud without intending to. You're going to have a misrepresentation of some sort or failure to advise. And I suppose you could say someone is deceitful without intent, but I'm still having trouble with how do you not intend to be dishonest? To me, that's more of an absolute than deceitful or fraudulent. So if you could help me with that, I'd appreciate it.
Well, and the best I can do, Your Honor, I think is I think when it gets to the topic of the dishonesty, it's the analysis the ABA had under the mental state, and I think what we have is under the mental state is what the jury instructions were and how they ultimately came out. Because basically the position we took is once there was a civil judgment in that case and the jury made this finding, we were not going to retry those issues before the disciplinary panel. That was not appropriate. The finding of the civil court was the finding of the civil court. And I think, but we felt like, yet the mental issue of dishonesty was still an issue as it relates to a factor. And that he I think will tell you he was not intentionally trying to be dishonest to anyone. He will tell you that the title company requested him to furnish the documents. He'd have given them to them. He told his client that. He said, if they ask me for the documents, I'm going to give them to them. So he knew that those were issues that were there, and the client knew those issues were there. But it is a difficult issue, is it when you're advancing your client's interest or representing or advocating for your client versus have you gone over the line? And I think this was a very difficult situation for Mr. Singer, and he made a bad judgment.
All right, thank you. You're out of time, but given the magnitude of what's at stake today, did you say your client did want to address us?
I did. If you could have 2
Yes,
minutes,
exactly.
I really appreciate that.
Of course.
Thank you, Your Honor.
Yes.
May it please the court, I had some prepared remarks, but I think I need to address some specific things that were raised in my counsel's presentation and deviate from those prepared remarks. The question was raised about the opportunity that was presented so that there wasn't deceit. And I wasn't necessarily relying on other people to find out what was going on. I mean, I disclosed to the title company that there was a non-cash item that should be regarded as a portion of the purchase price. What my position was is that I did not know that my client was committing fraud. I was not involved in the negotiations with the lender, and I did not know if a cash contribution requirement was still mandatory for this transaction to close. I told my client that if you're not being truthful with me, and there is still a cash requirement for this transaction, it's going to be found out at closing. But I never saw the lender's counsel take one step towards determining whether a cash contribution had been made. And I honestly tell you that my inference there is that in this course of dealing between this lender and this borrower that knew one another, that the cash requirement had been lessened and was not critical to the closing of this transaction. I never intended to defraud anyone. I was unknowingly made complicit in a fraud that was being perpetrated by my client. I concede that by not bringing to light certain facts, those were material omissions. I liken and analogize my situation to the criminal defense attorney who is faced with the possibility of a client presenting fraudulent testimony. I, from the beginning, made questions along the way that I received suitable answers for, and felt that without any evidence of fraud, with reasonable alternative explanations and mere suspicions, that I couldn't rat my client out. And I proceeded along the entire process, admittedly, and if I had it to do over again, no question I would do it differently, no question I would be more critical, no question I wouldn't take a lot of things at face value, but I was dealing with people who I had dealt with many times before who never gave me any indication that they were committing a fraud on the lender. These were complicated transactions. There were questionable aspects of it. I asked questions. I accept the fact that I may have crossed over ethical boundaries, that there may have been material omissions, and I'm not challenging the finding of the panel that there were violations of the ethical code. I believe in personal integrity. I believe in personal responsibility. I have lived my personal and professional lives morally and ethically, in my opinion. As a transactional attorney, I believe in win-win situations. I am respected by the parties that I have dealt with. These were anomalies in a 40-year career. I can tell you this is never going to occur again. My behavior in the 12 years since this occurred speaks to that. My supervised probation in the past year speaks to that. My 25 years of practice before these anomalies occurred speak to that. I am asking the court not to suspend me from the practice of law. I don't see what that would accomplish, and I do confirm my attorney's statement that the interests of the public and the bar are being met by the probation plan that has been implemented. I humbly ask that the discipline to be imposed upon me be the probation plan and not to be suspended from the practice of law. I did not intend to defraud anyone. I am sorry that people lost money. I am sorry that in this particular instance, I had a lapse in judgment and people did not realize what was going on. But I did not intend that this transaction occur in a fraudulent manner. I expected this to be a straight up real estate hotel transaction. And I apologize for what occurred. And as I said, I respectfully request the opportunity to continue to practice law. I believe I am a benefit to my clients. I believe that there's absolutely no chance that this is going to reoccur, and cite my 40-year career as evidence of that. And I'll answer any questions that any of you justices have.
Do we have any questions of the respondent or his counsel?
This is what I'm struggling with, counsel. On the one hand, you say you had a lapse in judgment, and on the other hand, you say you were used by a dishonest client.
Yes.
And they seem inconsistent to me. What was your lapse in judgment if you think you were just a pawn?
Well, because, it wasn't that I was totally ignorant. The fact was that I wasn't critical enough.
You knew there was a
I knew that there were suspicious issues. I knew that there was a cash requirement initially.
Right.
And we had a period of time.
And then you have a lapse of time.
Right. And I'm not involved with the loan negotiations except to negotiate the loan documents.
Right.
And then we get to closing, and my client asked me to ask the title company to keep this non-cash item off the closing statement. Frankly, I wasn't going to sign a closing statement that attributed $1.9 million to this management agreement, and it was only because it was being left off the closing statement, and that the closing statement read that a certain amount of money was due from the client that I felt able to sign the closing statement. I did not rely on other people to find out about the fraud. I didn't even know yet that the fraud had occurred. I did not know that my client was receiving money on the backside. I did not know my client had formed another entity to hide its receipt of those funds. I thought that these parties, the lender and the borrower, had reached some agreement about the cash requirement. And that was somewhat confirmed when it didn't come up.
So your lapse in judgment that you said you had was a failure to ask more questions.
At least, yes.
Okay. Thank you.
Any further questions? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
Justice Breyer, I would just like to highlight some testimony that I think would further hopefully answer your questions. This is the transcript of the hearing at page 53, and Mr. Singer is explaining, and I quote, "The closing statement I signed said amount due from buyer of $1.7 million in round numbers. I didn't. My client had asked that the non-cash credit not be reflected. And I assumed, in hindsight, that was because they didn't want it highlighted when the lender saw the closing statement. But in my own mind, I didn't want to put on the closing statement a management agreement and give a $1.9 million value when it was valueless. So I felt that the closing statement, as it was approved, was less fraudulent than if there had been a non-cash credit shown on the closing statement." And I believe in my brief, I noted that there was an intent to hide, and there was an intent not to follow up and ask questions. He testified that there were suspicions that there was something amiss going on, and instead of requiring the information about whether or not there had been a subsequent agreement come forward, just ask that question. It's not eliciting any negative on your client. It's just, has the situation changed? And then as a result of that, you can make a determination. But it appears from his own testimony that he made the conscious effort to intentionally deceive and not be truthful. And I think, Chief Justice, your question about dishonesty, there isn't gradations when it comes to that. You either are honest and open or you're not. And I believe in this situation we have an intentional act of dishonesty, fraud, and deceit. And I would ask that this court affirm the panel findings and order of suspension.
Any questions of counsel? Thank you. Thank you all for your comments this morning. Take this matter under advisement.